Hello, everyone, and thank you for joining our panel that looks at trade governance and development objectives and asking whether or not those two are irreconcilable. My name is Desirée LeClercq. I'm from Cornell University, and it's my pleasure to moderate today's panel. At the outset, I'd like for you all to know that today's session is being recorded. I'd also like to take a second to thank the SIEL organizers for such a well done, well organized conference so far. I, like many of the rest of you, have really enjoyed watching the panels, and I've really enjoyed seeing how everything has been handled so professionally over such trying times. So just a quick nod to our great organizers. I'd also like to thank our panelists who have put together some incredibly interesting and relevant papers for today's discussion, looking at the tensions in development, which is something that comes across in so many different forums, whether it's through the UN system, through trade governance, through public law, trade agreements, investment agreements. The issues surrounding development are so nuanced and so challenging that I really appreciate the various perspectives that today's speakers have brought to the table. Now, without further ado, I'd like to go ahead and open up the stage. To the audience members, I believe that the chat should be open. So please send questions or comments as they come, and we will address them in order. So the first paper to be presented today is by Xinyan Zhao, who's a PhD candidate at the University of Lausanne in Switzerland. He is presenting his paper entitled Integrating the UN SDGs and the WTO Law, which explores the integration of SDG rules into WTO law and proposes a new WTO proportionality test and associated dispute settlement rules and practices. So Xinyan, the floor is yours.
So thank you, Desiree, for your introduction. So the title of my research is Integrating the UN SDGs into WTO law. WTO members, and most of them are also United Nations members, are committed to achieve the 17 UN SDGs as of 2013. But we all know that the Sustainable Development Goals are not legally binding commitments, but rather initiative goals. And the progress of the SDGs is lagging behind the schedule. It is argued that WTO law can be used to strengthen the implementation of the SDGs. Namely, currently WTO law plays a role in creating the policy space for the implementing measures for the SDGs. Namely, the GATT Article 20 provides a legal basis for defending the legality of the implementing measures for the SDGs. WTO members can, in principle, enact and enforce any law or regulation relating to the implementation of the SDGs unless the law or regulation does not constitute, unless the law or regulation constitutes a discriminatory treatment or protectionism. However, I contend that the GATT Article 20 is not enough to strengthen the implementation of the SDGs. Why? Because of two reasons. First, WTO law does not provide legally binding sustainable development commitments, nor does it ensure an objective assessment of the measures relating to the implementation of the SDGs. So my paper studied how to address these two problems. So in order to ensure an objective assessment of the implementing measure for the SDGs, I define the WTO proportionality test. Currently, panels and the AB take the necessity test to assess the legality of the implementing measure for the SDGs. The major problem is that panels and AB can second guess the level of protection chosen by WTO members, and as a result, can lower the level of protection claimed by the member states. So the main idea is that an objective assessment standard of review does not imply that the prevention of protectionism can come at the expense of the implementation of the SDGs. Namely, if panels and the AB finds a measure is used to achieve one of the SDGs, but it is unable to achieve the level of protection chosen by WTO members, panel and AB must find and recommend a detailed implementing measures. Otherwise, that implement measures that can achieve that level of protection chosen by WTO members. Otherwise, they must maintain the previous measure taken by WTO members. Secondly, I also realized that it is not appropriate to take the same test to assess the legality of all the implementing measures for the SDGs, because these measures have their specialty. The classical necessity test contains 3 steps. So the first step is the suitability test, the second the necessity test, and the third is the proportionality test in the narrow sense. I argue that panels and the AB should simplify their analysis when facing off 2 groups of disputes. The first group of dispute is relating to chronic disease like EC homelessness, and the second group relating to disputes about imminent and severe risks like Drea radionuclide. In this dispute, the necessity and the proportionality of implementing measures are often difficult to be assessed. So now we move to the second problem about how to provide legally binding sustainable development commitments. In order to provide new commitments, negotiating new rules, new WTO rules is imperative. Nevertheless, there is a diversity of views on the contents of sustainable development commitments. Namely, we don't know which sustainability standards WTO members should apply domestically and both at the international level. I recommend that WTO members should negotiate 3 groups of rules in 3 different and separate multilateral trade negotiations. Firstly, they need to negotiate rules relating to an objective assessment standard of review. And secondly, they could negotiate rules relating to food security, public health, economic prosperity, and environmental protection. Finally, they should negotiate rules about international law and human rights. In this way, I prefer to ensure the efficiency of negotiation. And moreover, I realize the importance to achieve the optimal sustainable development, namely achieving at the same time the SDGs and the fundamental human rights. So I recommend that WTO members can integrate as much as possible human rights rules into their FTAs. The idea is that if we can maintain an appropriate relationship between WTO rules and FTA rules, we can achieve the achievement, we can promote the achievement of the optimal sustainable development. So these things are the most important ideas of my papers. I hope they are interesting for my audience and my colleagues as well.
Thank you, Xinyan. I really enjoyed reading your paper because, most people will make the claim that the SDGs, the Sustainable Development Goals, should be incorporated at the WTO and, through trade agreements, but they don't actually say or explain how. So I appreciated the second part of your paper, which really gave us something to think about as to what that architect could look like. Nevertheless, your paper suffers, I think, from one of the weaknesses that all of our rights-based papers suffer from in the trade discourse. And that is, it rests on the premise that WTO members want the SDGs to be integrated into WTO rules. And we know from the previous and long-standing history, for example, with labor, that getting this type of consensus has been thus far impossible. You accuse governments of kind of being hypocrites, and many of us would say, well, yeah, of course they're in a way being hypocrites, but in a way, why would powerful states want to give up their discretion of defining rules such as sustainable development goals? Why would they want to cede that authority to a multilateral platform? So one thing that I would like to see in these papers isn't just a discussion in the abstract that the SDGs should somehow be incorporated, but actually explaining who's going to translate the SDGs, which by definition are goals, they're aspirations, they're not the means to achieve those goals, they're not the rules. So who's going to translate these goals into concrete rules that can be agreed upon by the complex membership of the WTO? Is it going to be the powerful states that interpret those and apply those as they will? Or will it be the WTO Secretariat? And if it's the latter, isn't the WTO then doing exactly what members are upset that the WTO is doing, which is broadening its mandate and really, stepping outside of the mere interpretation of WTO rules and actually going into defining them? So I think all to say that I think that there's a first step that's being missed, and it's being missed in a lot of the papers we'll be discussing today, which is, it's one thing to say, I'd love to see this ambitious rule somehow be included at the WTO, and actually taking the harder step, which is saying exactly what that rule would look like. And, especially if it's going to be uniformly incorporated into all of the WTO's processes. So that would be my question / comment. Sparsha, did you have any comments or questions?
Sure. Thank you for the presentation. So I remember references to embedded liberalism within your paper, and I found that very interesting because there is now talk about going back to embedded liberalism in the WTO, because we now have more nationalistic tendencies across the board. So I just wanted to know what your perspective on SDGs and embedded liberalism within the WTO framework was. Thanks.
And Josephine?
Hi, Xinyan. Okay, so reading your paper, what came to my mind was just like Professor LeClercq said, how then do we determine these rules? How do we incorporate them into the WTO system, considering the fact that we have developing countries, developed countries, and it sounds like the same issues with SDGs will come up again about, oh, these goals are too much for developed countries, for developing countries to achieve. How then do we narrow it down? I don't know if you have any thoughts on that. Okay,
then finally Rizwan, and then Xinyan. We can't wait to hear your answers. Rizwan?
Yes, I think I would like to first answer the question of Sparsha, maybe because I think the question of Desirée and similar. So regarding to the embedded liberalisms, I think, okay, so right now, if we think it's inappropriate to continue use to direct the WTO law, which is a replacement, in my papers I argue that so in the part of negotiation, we should still need some economics ideology. I'm not expert in this field, but about the legal process, I emphasize the importance of the rule of law. So we need not to be intertwined with others' politics in the process of legal analysis. We just focus technical issues relating to law. So, and I think this is also easier for panels and appellate to follow the rules and to make a good decision. And with respect to the how to determine rules and integrate the rules into WTO law, and also who determines these rules? The question asked by Desirée, our moderators. I think I would like to mention the ideologies always mentioned by Professor and Anna Peters, like the constitutionalization theories, like we should hear the people from the below. So what the rules should be sustainable development rules. It must be answered by people. So who is really directly relevant to these rules. And this is very important. So we have two aspects within the WTO system and outside the WTO system. Outside the WTO system, so in democracies, I think there is a parliament, and we already see the progress of pushing new rules into domestic laws. For example, in Switzerland, we have referendums to push new environmental protection rules and the cooperation responsibility into domestic laws. So although it's failed, but nearly success last year. So I think this is a trend, and we will see some success in the future. And if we got these rules in domestic laws, we will see how politicians make a determination to get this rules, bring these rules into WTO law. So within the WTO system, the countries will play a very important role to negotiate these new rules and integrate sustainable development commitments into the WTO law. Currently, the United States has made a proposal which is, in my thoughts, is very interesting, ask country to follow the international standards about environmental protection. So namely, if they set standard below of the international standards, this could be this rules or regulation could constitute somehow actionable subsidies. So it will cause the violation of WTO law, and other member states will have a right to impose countervailing duty. So it's very interesting ideas. We will see what will happen. Yeah, this is my answer.
Wonderful. Rizwan, did you have any questions?
Yes, thank you, Desirée. And thank you, Xinyan, for your excellent presentation and also for the paper, which I think is a very good one. Now, I particularly like the idea of using a proportionality test by the dispute settlement body. Now, my concern with the proposal, as much as I like the idea, my concern would be that you, I think, are aware in many cases, including sensitive B-Form case and in some other cases, many scholars and policymakers, both sides of the Atlantic, they have expressed their own concerns that are the panels and appellate body going too far? Are they intruding on issues which could perhaps be better left to the WTO members? So if we see a more intrusive, expansive role from the DSB through some form of proportionality test that I think you alluded to in your written paper, do you see that this dispute settlement, which is already in some constraint, appellate body is effectively moribund? Do you see further challenges to the DSP? I would appreciate your thoughts on that. Thank you for an excellent presentation.
I think so. If we look at the WTO jurisprudence, we will find that the panels and ABs use kind of test methodologies, and the test is always named as the necessary test, but also proportionality test by some scholars. So it depends on the personal views. In future, I think so, it's possible to develop new tests and to use this in the future, because panel always make some developments to about the test methodologies. So this is my answer, I think.
Thanks, Xinyan. And one last kind of parting thought that I might leave you with. When you're proposing this proportionality test, again, I think that that's the strength of your paper. One thing that you might consider is narrowing the SDGs to what you're mentioning, which is rules like the environment, where the WTO has already taken some really concrete steps and developed a certain level of comfort in addressing within trade rules. I think when you refer to the SDGs in the abstract, you're bringing in some goals, some sustainability goals that are far more controversial. In labor, for instance, we've seen that there's no consensus on this. And yes, USTR has introduced a new forced labor provision in the fisheries context. But even that within this particularly narrow category and a particularly narrow application is getting a lot of pushback. So I think when, there's two parts of your paper, one is setting up the case for incorporating these rules, and then the second part of your paper is examining how those rules will be implemented. In the first part, you don't want to lose your reader by putting something so ambitious that it doesn't seem like it'll ever make it to the second stage. So you seem to know a lot about the environment, and maybe you could reconsider how to focus this first part of your paper to really setting up the strength of your arguments on a platform where readers will say, oh yeah, actually I could see that there's a need for that, because clearly the environment has become kind of a familiar topic in WTO circles, and I could really see how that would drive forward.
Thank you for your comments. Yes, very insightful.
And we all look forward to seeing the final product. I'd like now to move to our second paper to be discussed today, and this is by Rizwanul, who is a professor at the North-South University Department of Law. He is presenting his paper, Taking Special and Differential Treatment Beyond the Realm of the Hortatory, so a very relevant follow-up paper. He analyzes the limitation of SDT provisions with reference to the relevant WTO jurisprudence. So without further ado, Rizwan, the floor is yours.
Thank you, Desirée. Good morning, good afternoon, or good evening, depending on wherever in the world you may be. Now, the special and differential treatment provisions, or STD, they have been an integral part of the GATT and WTO for many years, particularly after the Habeler report and then the introduction of Part 4 in the WTO, in the GATT, and then subsequently through the enabling clause, and also in many WTO agreements. I think currently there are more than 140 STD provisions in various WTO agreements. The STD provisions are there to accommodate a reality that while the GATT WTO regime is based on the premise of reciprocity and most favored nation treatment, that you cannot really distinguish or should not distinguish between your WTO partner states, but it has always accommodated STD provisions in one way or the other. Now, if that is the case, the scholars, the observers, policymakers, whoever may be aware of the operation of the STD in last couple of decades, I think most would agree that a very overwhelming number of the SDT provisions have not really materialized to any significant degree. And one very common feature of those would be that many of those provisions are not really crafted in a way that you could argue that they are legal obligations, or they offer anything to their intended beneficiaries in concrete terms, or they impose any real obligations on the developed member states. Now, there may be several reasons for this to happen, but in my view, the most significant reason for this is that most of these SDT provisions have been crafted in a way that they do not go far enough. In my written paper, which still is a work in progress, I refer to 3 cases which are relating to the SPS agreement, the TBT agreement, and also the NTW agreement. In those cases, in the SPS and TBT cases, the developing countries, when they made their case to the WTO panel and argued that the developed country, when they crafted their trade regime, their SPS or TBT measures, they did not take into account the concerns of the developing countries, the beneficiaries of those provisions. And in both of the cases that I have mentioned, US School and also EC Biotech, in my view, the panel very rightly found that the text of those agreements did not really oblige the US or the EC to do something which would really benefit the developing countries. All, in essence, the developed countries were needed to do was to ensure that they take into account. Now, as all of us would know, to take into account and to act based on that are 2 different things. If we only have to take into account the concern of someone else, we can always claim that yes, the others' position, others' concerns were taken into account but not were acted upon, and still there would be no violation. Now, if we contrast these cases and the overwhelming majority of SDT provisions with something else, like the de minimis rule in Article 9 of the Safeguards Agreement in the Dominican Republic safeguard case, we'd find that the panel was quite strict in interpreting the de minimis rule. The panel said that any WTO member who wants to impose a safeguard measure has to follow the de minimis rule. There would be some leeway in following it, but they have to ensure that any developing country whose individual export share is less than 3%, or developing countries whose collective trade share is less than 9%, they must be excluded from the safeguard. Now, what do I take from these two different line of cases? My argument is that there should be some sort of a WTO commission which should consist of experts who should not have any direct affiliation with the WTO member states. They should study these provisions, and this was a part of the Doha mandate, the Doha Ministerial Conference mandate, that the STD provisions should be looked into more carefully. And another thing that I argue in my paper is the practice of self-declaring developing countries should change, because you see, when the WTO, when the GATT was founded, there were only perhaps 11 member states who were classified as developing. Now that WTO is in place for about 2 decades and a half, nearly 2/3 of the WTO members are classified either as LDC or developing member states. Now, it doesn't necessarily mean that I fully support what the US has proposed in the WTO. It has essentially proposed 4 criteria for a state to be ineligible for SDG benefits. But I still feel that the US proposal has its merits, in the sense that countries like South Korea, Singapore, Israel, Saudi Arabia, they perhaps cannot or should not be treated like some countries in sub-Saharan Africa or some smaller economies in Asia. And once the STD provisions are to be changed, I think it would only change if this practice of self-declaring as developing countries, member states in the WTO, change. If this does not happen in one way or the other, I do not find it really a real prospect that the STD provisions would move any further and would really help benefiting its intended beneficiaries. So that's the main arguments that I have tried to present in my paper. I look forward to your questions. Thank you.
Thank you for your presentation, Rizwan, and for drawing attention to this issue. You know, it's funny, in some ways it overlaps nicely with the question of the SDGs, because in both areas, we're noting an absence of rules, an absence of something concrete. And particularly, you know, it resonates in the rights space, where the criticism is often that language in trade instruments is too hortatory, it's too soft, and there isn't a binding, concrete rule that would really help further the discussion. However, that's easier said than done, this concept of translating, once again, something that's hortatory into something that is concrete. I was hoping in your paper that you would provide an example of what a concrete SDT provision would do. And you do make an attempt at that, right? So you focus on DR Safeguards case, interpreting Article 9.1 of the agreement, and you provide the language that the article provided, and then you discuss how the panel interpreted it. And you're right in that the proviso that you cite is actually concrete, it provides a rule, but then the panel quote that you give almost undermines your point, because the panel quote looks at the application of the rule, and according to your paper says, well, you know, merely means that the party adopted all reasonable measures available to them, and that regardless of what measure the party chooses, it just has to show that it made the efforts it can to exclude those members covered. So to me, you kind of illustrate how even a concrete rule can be interpreted by a panel to become hortatory or to become subjective, thus anchoring us to the very frustration that brings us here today, which is that we really want something that removes discretion, right? And provide some concrete teeth or some concrete guidance. And so I almost wonder if the issue here isn't with the language of the provision or the language of the rule, but rather in the ability of the panels to do what they want to with that rule or with the hortatory commitment, that rather than holding governments to something concrete, they use what could be concrete or inconcrete and give those governments discretion and wide berth. So it was just something that crossed my mind when I was reading your paper, which is that maybe the problem isn't in the text after all. Xinyan, do you have any questions for Rizwan?
Currently, I have no questions. Thank you.
Sparsha.
Yeah, thank you. Thank you for the presentation. I was just wondering if you look at special and differential treatment more as an exception to our GATT and WTO framework, or do you think it's part of the WTO framework? And then depending on that, how would you look at translating the hortatory nature of these commitments into something more concrete? Thanks.
Josephine.
Hi, everyone. I was just smiling at Sparsha's question because I've never thought of it that way, as the SDGs being exceptions to the rules. Sounds like it's part of the rules. I'm not going to answer your question. So considering the fact that no matter how, it seems like no matter how the language of the SDGs are, it sounds like the panel will still construe in a way that it still give countries discretion. I'm just thinking that, is it possible that if we have like a standard legal criteria to say, oh, if your interpretation ticks these boxes, we can say that you have fully implemented the SDGs in the sense that you have considered development, financial and trade needs of the developing country.
Rizwan, would you like to respond?
Yeah, sure. Thanks to all my co-panelists for their questions. Let me try to answer you. First of all, if I may refer to Desiree's question, you see, although you could argue that the panel still gives some degree of latitude, I would try to argue that at least it's saying that you have to ensure that you exclude them. So the end result is, at least in the latter line of cases where the provision is stricter, the provision is more concrete, the panel did not really leave it to the member states that, okay, you just take into account the interest of the beneficiaries and then you have fulfilled your legal obligations. In the second line of cases, at least there was this observation that doesn't matter how you calculate it, what means you adopt, you still have to apply the rules. So I would not really think that with a more concrete set of provisions, the panels are really left with the same space. I think their scope to act and their scope to decide cases more decisively would be significantly more. Now, obviously, you and I'm sure many others might argue that international agreements, like I think Philip Sands in one of his texts, he wrote that international agreements are agreements to disagree, that states often cannot really agree on specific things. So the lowest common denominator becomes the treaty law. So yes, common criticism level that my main thesis could be that, well, SDGs are like this because the GATT and WTO members wanted to be like, to see these provisions like this. So they are no accident, they are deliberate choice. Even if it is so, I don't think that it was envisaged in 1947 when GATT was drafted, or later on when the Part 4 was made a part of the GATT, that a very high percentage of WTO members would be classifying them as developing countries. And another point that the US has made in its submission is when the larger developing countries would be eligible for some SDG leeways, it would mean that the LDCs or smaller developing countries who could have benefited from those provisions, perhaps their exclusive benefits are not being enjoyed to the extent that they could otherwise. Now, with regard to Sparsha's question, I'll have to say that I haven't looked into that question as specifically or as pointedly as you have raised. But with the kind of GATT practice that we have and also the WTO practice, I would tend to think that this is no longer just an exception. This is more a part of GATT and WTO practice. That would be my take, but I have to concede that I haven't looked at that question as critically or as carefully as I perhaps could or I should have. Josephine, I would have to request if you could please repeat your question. I seem to have lost your question. If you don't mind, could you please raise it again?
Just saying that considering the fact that we said the SDGs as they are, they are not being enforced in a way that they're not being interpreted in a way that it sounds like something enforceable. And considering the fact that we still want countries to have discretion, so we are not forcing them to say, oh, this is how you should implement SDGs. What if we have something like a standard legal criteria to say, if your SDGs flows with, well, the WTO itself has decided in EC tariffs that SDGs should enable development, financial and trade needs of developing countries. So if we have like legal criteria to say, if your SDGs promotes so and so, has been pertaining to development needs of developing countries, instead of having like a standard or a concrete words for SDGs, and make them enforceable within the trade system.
Thank you. Surely what you are saying have merits, but in that line of action, my particular concern would be the same that I have about Xinyan's proposal or sort of argument that the proportionality test to be used more rigorously, more systemically to give effect to some SDGs. I am not particularly sure that the panels and the appellate body in the current state of things and with the text that we have in place are in a position to give more concrete directives. And even in the EC tariff reference case, which you have cited in your paper, and actually that's the main case in your paper, even in that case, you would perhaps agree with me that in that case, the appellate body hasn't gone as far as to say that the development goals that the GSP granting countries are setting for the intended beneficiaries have to be doing this or that. In my reading of the appellate body ruling, I think they have given some substantial leeway to the GSP granting countries, and I think many scholars have criticized that approach of the AB. So I'm not very sure that this can be done at the DSB level by the panels, or if the appellate body is functional in any near future, they could achieve it. So that would be my take on that. Thank you, Josephine.
Thank you again, Rizwan. And I just want to remind the audience that if you have any questions, please put the questions either in the public chat or in the questions function so that we can make sure that we aren't just answering our own questions and having an internal dialogue here, but also that we incorporate all of you and your perspectives into the mix. Alex, unfortunately, had a family emergency, so he cannot join us today, but we are now moving on to our next speaker, who is Sparsha Janardhan. She is an LLM candidate and Jardish Fellow at Columbia Law School. She's presenting her paper, World Trade and Customs is Self-Declaration of Development Status a Customary Practice at the WTO. So it streamlines nicely. She analyzes claims under the SDG provisions to see whether self-declarations truly constitute customary practice. So without further ado, Sparsha, the floor is yours.
Thank you so much. Good morning, good afternoon, good evening, everyone. As Desirée mentioned, my topic for presentation today is whether self-declaration of development status is a customary practice at the WTO. Briefly, by way of background, as we know, the question of who should be a developing country has become a huge reform agenda at the WTO now. It's being led by the United States, which has proposed certain objective criteria for defining developing countries in current and future negotiations. So the main argument that the United States makes is that self-declaration applies only, results in the trade rules being applied to only a small number of developed countries, and that really changes the balance of rights and obligations that the WTO framework and the GATT is supposed to have. So in response to this, we had a group of developing countries submit their communication to the WTO. So the main argument that these developing countries made was that special and differential treatment is actually a cornerstone of the WTO. And they argued that self-declaration is a long-standing practice with recognized legitimacy, and which is why it is a customary practice of the WTO. So taking from this, my paper tries to examine if this claim has any legal validity within the WTO framework. Now, the term customary practice actually finds mention in Article 16 of the Marrakesh Agreement establishing the WTO. Now, what Article 16 provides is that the WTO shall be guided by the decisions, procedures, and customary practices of the GATT 1947 contracting parties. So it is a sort of a guidance clause that provides continuity between the GATT 1947 and that of the WTO. Now, because this provision is within a treaty constituting an international organization, a question that arises is how should one interpret such a provision? So in this regard, one can refer to Article 5 of the Vienna Convention on Law of Treaties, which provides that the Vienna Convention applies to such provisions within constituent treaties of international organizations. But what Article 5 also provides is that any rule of the international organization will take precedence over other rules within the Vienna Convention. So looking at it from this perspective, Article 16 can perhaps be looked at as an interpretative guide to the WTO, because it is asking the WTO to look into the decisions, practices, and procedures that were there previously. Now, whether we can apply Article 5 is something that's still unclear, because, as I said, Article 16 is like a continuity clause between the 47 GATT and the WTO. And as we know, the 47 GATT never really culminated in an international organization through the ITO. So what we have is a multilateral trade organization in 1947 and certain practice of members. And Article 16 is now asking us to be guided by such practices going forward in the WTO. So because of this lack of clarity in the application of Article 5 of the VCLT, one can then look to perhaps the general rules of treaty interpretation you find in Articles 31 and 32 of the VCLT. So now here, panels and the appellate body have had the opportunity to look at Article 16 of the Marrakesh Agreement. And while the term customary practice has not been interpreted in itself, the phrase taken together has been interpreted to mean acts or norms that are a result of the contracting parties acting jointly. Now, this terminology is a little vague, and one does not really know what they mean by contracting parties acting jointly. With that idea on the one hand, we also have the concept of subsequent practice that is recognized within Article 31 as a tool for treaty interpretation. Now, panels and appellate body again have had the opportunity to look at what subsequent practice means, and common concordant practice of member states taken together has been held to be subsequent practice. But what this leaves open is the fact that silence of member states can at some point in time also be considered as part of the subsequent practice, depending on the facts and circumstances of the particular norm. So we basically have the concept of customary practice in the language of Article 16, and you also have subsequent practice as a tool for treaty interpretation, all of which also takes into account how Article 5 plays along in this entire kind of a dynamic. So with all of this, my argument is that Article 16 usage of the term customary practice is perhaps a sui generis terminology that really does not have anything specific attached to it. What one can understand very broadly is that it is perhaps the act of contracting parties acting jointly. Now, with that kind of a legal framework in mind, I look to what was the practice of contracting parties from 1947 to 95 and then post 95. So from 1947 to 1995, as we know, the GATT did not define the term developing country or least developed country at that point. But we had Article 18 of the GATT, which used terminology like low standard of living or early stages of development, hinting at certain differentiation in the economic levels of development between member countries. As new members joined the WTO, there was a push to include more special and differential treatment provisions within the GATT framework. UNCTAD in the 1960s played a very important role in incorporating these SDT provisions within the GATT framework. So as Rizwanul mentioned, we first had in the 1960s the addition of Part 4, that is trade and development within the GATT 1947. So that uses terminology such as non-reciprocity in obligations based on the development, financial, and trade needs of countries, perhaps suggesting it's some kind of a differentiation between developing countries. So second, in the 1970s, we had the enabling clause for unilateral trade preferences of member countries. Now, paragraph 7 of the enabling clause also provides for a vague form of graduation in terms of members having to undertake greater obligations as their economic situation improves. Third, we have a few instances of panel reports such as the SIEL on Article 18 applications case, which actually interpreted the terms low standard of living and early stages of development by referring to economic indicators such as GNP per capita and other criteria. Fourth, there have been instances of the United States communicating to the GATT contracting parties that developing countries should at some point actually graduate and take fuller obligations within the GATT framework, moving on to the WTO. So what all of this taken together seemed to suggest is that while self-declaration was perhaps the starting point to identify who are developing countries, there were instances of differentiation or graduation when negotiated specifically between the contracting parties. Now, this practice seems to have continued within the WTO framework. So the two main examples are that of accession protocol and that of Article 27 in the SCM agreement. Now, accession protocol, as we all know, the acceding country would have to negotiate the terms under which it would join the WTO. So as China, taking China as the best example, you have examples of special and differential treatment provisions being negotiated specifically when the country accedes to the WTO. Now, with respect to Article 27 and Annex 7 of the SCM agreement, you have the prohibition on export subsidies not being applicable to these group of countries as long as their GNP per capita is 1,000 USD for 3 consecutive years. So within the WTO framework as well, we see this sort of self-declaration being the starting or the default rule, but again, subject to differentiation or graduation in certain instances. Now, this is where the United States proposal and what other countries are saying kind of comes into play. Now, the United States has proposed sort of a horizontal criteria or of objective factors to look into when determining who should be a developing country. The European Union, on the other hand, in its recently released trade strategy, argues that it supports special and differential treatment, but also is looking for graduation in certain cases. They do provide some objective criteria, but their main approach seems to be that it should be done on an agreement by agreement basis. So now, taking the legal framework of customary practice that I explained earlier, and then the practice of GATT contracting parties in the 47 era and post the establishment of the WTO. My argument in the paper is that self-declaration is the starting point of the default rule, but that is not unconditional. So self-declaration taken together with graduation and differentiation in certain specific instances that are negotiated between the parties would constitute customary practice. So both of these taken together would constitute customary practice. Now, the main consequence of this is that the United States proposal of a horizontal criteria would perhaps be in violation of what we understand from the term customary practice. At the same time, what developing countries argue as self-declaration in itself being a customary practice may also not withstand the test of Article 16 customary practice. So yes, thank you so much, and I'm looking forward to your comments and questions.
Thank you very much, Sparsha, for that excellent presentation. And for those of you who are interested in the history of these provisions and how they came about in national practices, I advise you all to keep an eye out for Sparsha's paper once it's finalized, because I think that it really will provide a valuable contribution to kind of the trajectory and our understanding of these provisions. And I actually think that you did a better job just now explaining this than you had in your paper. So I'll just raise it more as a reaction to the way that your paper was drafted. And that was that, you spend a lot of time explaining the history and the relationship between the provisions and the rules with respect to self-declarations and the national practices. And you say, so, here is my view on the legal interpretation of customary practices. And I think that that was very compelling. But then you explain how, under WTO rules, a member can challenge self-declaration. And so my question then becomes kind of like, well, what's the importance of understanding this? Like, why did I just spend all of this time learning about customary practices if pursuant to the rules, another state can just question it and invalidate it? Anyways, you need to argue and explain kind of like why developing countries, quote unquote, vehemently oppose those provisions, because your explanation of how US trade practices do not turn so much on the development status, but on other factors, kind of, it impacts internal WTO rules, it's subject to challenges, kind of the sort that diminishes the importance of this customary practice. So all to say, I really enjoyed learning more about what constitutes customary practice. And again, I think that that will be very important, an important contribution to the literature moving forward. But I wasn't entirely sure what the problem was, or why, for the purposes of your article, we should really care about what customary practice is for your thesis. So again, like I think that just now in speaking about it, you kind of did a better job of explaining that, but I wasn't quite sure from reading your paper how all of those parts fit together. Josephine, did you have any questions?
Just like you said, I understand your paper better from the presentation than reading the paper, and I quite agree with you that it sounds like within the WTO, it's clear that there's kind of like objective criteria for determining whether a country is developing or whether it's a developed country, and we see the practice of graduation inherent in GSPs granted by US and EU to developing countries in sub-Saharan Africa and some other Latin American countries. So the text on whether it's customary practice or then customary international law, or it may not be relevant in this instance, but the question remains whether we can say developing countries can self-declare themselves as developing countries. Say that I do not think self-declaration is going to provide any of achieving the goal of the WTO, which is to enable countries that are not on the same economic level to apply the same trade rules as countries that are already developed. Because if you see in sub-Saharan Africa, we see some countries that have more developed economy than others. But then if we want to say you can self-declare, it then means that within Africa, we see countries who are not on the same economic level expected to implement the same laws. So self-declaration is problematic for me. It is problematic, but then going by the United States criteria may be too much for us to say that we are differentiating between countries as developing and developed. I do not have any question for you. Your paper is quite clear to me from the presentation that you have made now.
Xinyan.
Yes, it's for me it's a very interesting paper. So I really enjoy it, especially your conclusion. Especially is very interesting. I quote the conclusion. I repeated it quickly. The practice of GATT members during the 1947 era is viewed as the practice through and specific commitments suggest that self-declaration of developing country stature subject to differentiation and graduation in certain instances taken together can be considered as customary practices. I got a feeling that the desirability of self-declarations is kind of adopters, because even though a member state self-claimed that it is a developing country, it may not get the same special and differential treatments as other developing countries. And you think that this differentiation and the graduations treatment also constitute a customary practice, but I think, and it's also relating to the EU's proposal, which could be more practical than the US proposal to amendment. So my question is, do you think why you think the differentiation and the graduation should be a customary practice? Because to amendment, there are many countries resist to this kind of treatment, because they would say the developed countries just not carry out their commitment to support developing countries. So this is my question. Thank you.
And finally, I understand that Rizwan has more than one question. So actually, Sparsha, do you want to try to answer the questions that have been asked, and then we'll turn to Rizwan? And if we cannot finish, then what we'll do is Josephine will have her presentation and discussion, and then we will revisit unanswered or unasked questions. Does this sound okay with the rest of you? So Sparsha, why didn't you go ahead and answer the other questions, and then I'll turn to Rizwan.
Yes, thank you for the comments and questions. I think that's really helpful for me to also think this through. So I think maybe I should explain again why I arrived at this research question and why it is limited to this kind of an analysis. So once the United States put up its proposal at the WTO, the developing countries, that is India, China, South Africa, Bolivia, etc., they really made this specific argument where they said self-declaration of developing country status is a customary practice under Article 16.1. So this legal claim that the developing countries made is what got me thinking about, is that really true? Like, can they claim that as a point of legal matter under Article 16 of the Marrakesh Agreement? So when I looked at that, and that's where my analysis kind of flows. So at this point, I've refrained from making any normative assessment on whether there should be graduation or differentiation, and if that's a good thing for developing countries. But I have limited myself to keeping it to the legal validity of their claim that self-declaration in itself is a customary practice, as compared to what the United States has proposed and how that would play out in the entire framework.
Thank you.
All right, so we only have 2 more minutes allocated for this presentation. So my proposal is we go ahead and turn to Josephine so that, Rizwan, we don't interrupt your questions like mid-flow, because sometimes that will be complicated. So why don't we just do everything in a block? So with this being said, and you know, clearly fascinating papers, because we have a number of questions percolating, but I'd like us to turn now to Josephine Adeyele, who is an associate with Ikeyi, Shittu and Company. She's written a very, very interesting paper exploring the extent of differentiation amongst developing countries permissible in the World Trade Organization regime. She explores the extent of differentiation amongst developing countries permissible under, in light of the decision of the appellate body in European communities, conditions for the granting of tariff preferences to developing countries. So we're leaving kind of the WTO a little bit and looking more at GSP eligibility and these preference programs. So Josephine, the floor is yours.
I'm happy to be able to present today, and let me just say that my paper is like a snippet of a broader research that I propose. So what you have there is not a conclusion on my real research question. Today I would like to just speak to exploring the extent of differentiation permissible within WTO using the SDGs. So the enabling clause permits developed countries to grant preferential treatment to developing countries. And we see that the United States and the European Union, which they're the most trading partners for countries in sub-Saharan Africa, we see that they've granted GSPs and PTAs to countries in sub-Saharan Africa. For example, we have the African Growth Opportunities Act, wherein a number of products and a number of services are listed for countries, for developing countries, that developing countries can import to exports to the United States. And then we see that within the WTO, GSPs are legal because the enabling clause allows that. And then the goal of GSP is supposed to enable development for developing countries. And therefore, it is expected that any trade concession granted by all these developed countries, developing countries, should engender some form of economic development. But then we see that trade concessions are tied to conditions, non-economic conditions. So we have labor standards, we have environmental protection, and some other things. And then the argument has been posed that this is kind of like an extension of the legal regime in a developed country to a developing country. And while this is an argument going on, but still it is a practice that goes on. As a matter of fact, the AGOA, that is the African Growth Opportunities Act, had been extended on up to a longer period of time. So we see that it's kind of like something that we should keep on, that we should expect to all see in GSPs or preferential trade agreements that will be granted to developing countries. And like I mentioned earlier, we see that if we put all these provisions on non-economic conditions in GSPs, we see that some developing countries will be eligible going by those conditions. Some will not be eligible. Using the example of countries in sub-Saharan Africa, perhaps would expect a country like Ghana to be able to comply with provisions on labor rights or labor standards and environmental protection. But when we look at another country like South Sudan that is currently battling with other issues, non-economic issues, perhaps that is not what they are trying to pay attention to. So while you would see that a country like Ghana or any other country may be able to explore or take advantage of the benefits that the GSPs have provided, some other developing countries may be unable to take advantage of those benefits. So that is kind of like a differentiation already amongst developing countries. And then I went on to look at the decision of the appellate body in EC tariffs, where India sort of challenged the conditions in the European communities, the GSP granted to a number of developing countries then, and the way the European Union has couched their own GSPs, it's sort of to grant some extra advantage or benefits to countries that are able to comply with those conditions. So it's more like an incentive, much more than an eligibility criteria, different from the way the United States have put theirs. So the decision of the AB there is not to say that conditions in GSPs are illegal. They are legal within the WTO legal regime. But then it's the appellate body said that GSPs should go on to attend to development, financial, and trade needs. And we see trade agreements, we've seen that phrase, development, financial, and trade needs, come up. And that sort of leads to my question that I asked earlier, that what if we have like a standard legal criteria for development, financial, Because sometimes when you consider the conditions therein in all those GSPs, they are not really what developing countries are paying attention to. And this became very apparent during COVID when most developing countries, or even after COVID, now, like I live in Nigeria, so let me just use, I live in Nigeria and practicing in Nigeria, I see that what the government is really paying attention to is not about compliance with labor standards or environment or complying with environmental protection. Rather, they're trying to see how can we ensure that businesses continue even though we are unable to. So yes, the GSPs are there, the PTAs are there, and they're supposed to grant consensus developing countries. Well, developing countries are unable to take advantage of all these. Well, they do not comply with what has been stated there as eligibility criteria for those benefits under the GSPs. So what I propose is that rather than having a list of conditions that developed countries attend to development needs of developing countries, why not have something also that moves on to providing aid to more like providing capacity building for developing countries, so that even if they amend their laws, that is going through legislative process of amending laws to comply with labor standards, amending laws to comply with environmental protection, if we do not go ahead, if developed countries do not go ahead to actually ensure implementation of these laws, then it just becomes like we have a whole that are really not doing anything. So if, for example, a country like South Sudan decides to implement laws on child or of prohibiting child labor, and it's unable to enforce those laws because it's kind of like something that they have to do. They're at war. The law is there, but it's not being implemented. So I am thinking that if we have the law, which is good, so it serves like a legal basis for anybody to challenge anything that is being done within the country. But why don't we move ahead to ensure that there's actually an implementation of those laws, to ensure that there's actual development, not development on the papers, but actual development. So I propose that there should be provision of support and capacity building. There are lots of institutional problems with regulatory agencies in Africa. So even if we have been able to put all those requirements for us to take advantage of the GSPs, what if it doesn't engender any form of development? While it's been said that GSPs has enabled development in some industries, particularly the textile and the apparel in Africa, we see that most African countries still rely on export of Nigeria as an example, and with the fall in petroleum price in the international markets, it's kind of like there's no ripple effect of development back into the economy. So if there's no focus on export diversification, growth of industry would keep being at the same position of not developing. And then, I mean, GSPs will be there, PTAs will be there, but we won't see any form of development in all these developing countries. So I would, like I said, I would propose that even if we have conditions, non-economic conditions in GSPs, those GSPs should also go ahead to provide some form of support or capacity building for developing countries to actually implement whatever laws or whatever adjustment has been made to the regulatory framework within those countries. That's my paper in a nutshell.
Thank you, Josephine, and thank you for the great presentation and for the good paper. I enjoyed reading it. This is a particularly important topic. I think it's close to my heart. Before I joined Cornell, I was a director for labor affairs at the Office of the U.S. Trade Representative and worked on GSP and our trade agreements, including AGOA. So I think it's an important issue, and I think that further attention should be placed on it. Given my experience, though, I am going to push back on some of your assumptions that you make in your paper, not to say that one is right or wrong, but merely to reflect that I think that more evidence needs to be shown, at least in your paper, concerning some of the conclusions that you're drawing. So you mentioned in your paper that merely placing non-trade requirements, such as those governing labor and the environment and preference programs, is quote unquote ineffective at helping developing countries actually improve their national policies like worker rights, because there's no focus on implementation. I would draw your attention, I don't know if you're aware, one of the issues with the US and other trade partners is they're not great at publicizing their activities, right? So this is to no fault of your own. Maybe it's just an issue of information sharing, but the United States does have a triennial review of all of its GSP beneficiaries. It talks to post in the, in the countries in question to ensure not that their law exists. I mean, that's an easy desk review, but that it is being implemented in practice. It hears complaints from worker organizations, from environmental advocates and the like. Any issues of implementation that are raised by the social partners, by the State Department, what have you, become a critical point of discussion in deciding whether or not to continue providing benefits to that country. So for instance, while I was there, we placed Cambodia on watch because should that country not begin implementing its laws better, we were going to withdraw the benefits. And in fact, the EU did withdraw its benefits. So as far as the implementation, it's one thing to say, those efforts are not effective, and here's why, notwithstanding what's going on, here's my evidence that these things are still not being implemented, but merely coming up with a conclusion that it's ineffective kind of overlooks the activities that are going on and is a very controversial topic. So I would just urge you to treat it a little bit more delicately. You also mentioned that, and I agree with you, less sanctioning is more money, right? These are developing countries. Let's stop hurting them and let's start helping them. And I agree with you 100%. Again, though, I would draw your attention to the fact that these instruments do provide for capacity building and they do provide for technical assistance. While I was there, we were working with the Koreans and a number of other developed countries to figure out why our developing country trade partners were not invoking those provisions. So in other words, especially with respect to child labor, the United States cannot give that money away fast enough. I mean, they are desperate to provide technical assistance and capacity building. The issue is not the provision, the issue is the acceptance. So one thing that would be very interesting and would be a massive contribution to the literature is if you, particularly given where you are and the sources that you have, if you could start understanding better why the technical assistance and capacity building that is offered through these trade relationships is not actually trickling down into the countries that need them. Is this a question of not being requested? Is this a question of it just being window dressing and maybe it was requested and never facilitated? What's going on there that's actually preventing the technical assistance? And then finally, you mentioned that, you distinguish the US and the EU, and you say the US is really using this as an eligibility. The EU is not providing, or the EU's non-trade provisions are not just incentives, right? They go beyond that. I mean, one thing that I would raise your attention to as well, I mean, the EU is not just fluffy about these commitments either. The EU and the US at the same time were considering whether or not to withdraw benefits from Cambodia. The United States decided to cooperate with Cambodia. The EU the same year decided to withdraw their GSP benefits because of the worker rights criteria, amongst three others. So I would be careful in distinguishing how these trade partners are characterizing their GSP benefits, because in fact, I think that there's more similarities than one would assume, particularly given traditional differences between the US and the EU. So that's all from me. I mean, I could go on about this forever, but this is all the time I'm allowed. Rizwan, do you have any questions for Josephine?
Yes, thank you, Josephine, for your paper. Sorry. The questions that I would like to ask you would be, I mean, yes, on paper, the GSP is only for the developing countries, its intended beneficiaries. But if we look at the scheme, I mean, many GSP schemes, I'm not trying to be pointing fingers to any particular country because I haven't read them, at least recently, as carefully as I should have perhaps. But in terms of the design, I think there is not just a look at the intended beneficiaries situation, but also the GSP granting countries' economic needs and situation. So, have you really looked at this question that in drafting their GSP scheme, the tariff lines or the products, which products are eligible or which products are not eligible? What do the GSP countries do? And secondly, I think in your written paper, not so much perhaps in the presentation today, you have referred to the fact that some African economies who have benefited from these GSP schemes, they are not diversifying their economies sufficiently enough. Many of them just are exporting some petroleum products. So do you think that in the longer term, the GSP can help the beneficiaries in Africa and in other parts of the world in diversifying their export baskets? Because when a particular economy, and particularly these smaller economies who use GSP, if they rely too heavily on only some products, I think they are at a greater peril of uh, facing shocks when some particular products lose their demands in the export market. So what about the outcome in terms of product diversification? So thank you again.
Sparsha.
Thank you. Just a very quick question. So because GSP is at the discretion of the donor country, do you think having more regulation in terms of how that is done would actually work negatively in these developing countries being eligible or getting the benefits of the GSP at the end of the day?
All right, Josephine, would you like to answer?
Okay. So my paper, actually, I tried to narrow down my examples of advantages or benefits from the GSPs to African countries. So that's why I see me not making mention of other countries in Asia or other countries of the world that benefits from GSPs. So I tried to narrow down to sub-Saharan Africa. And just like I said, thank you for the insight, Professor LeClercq, about support that's been granted to developing countries. I guess I'll have to do more research on that aspect of why we do not see any form of development trickling down, because working with regulatory agencies every day is part of my work here in the corporate practice. I see that lots of improvement can be done in our regulatory agencies. I mean, the whole point of having GSPs is that we can improve on export and we can put more products out there. That also supposes that there should be more businesses that are encouraged to do business. But if the environment is not friendly for businesses to be conducted, businesses are not up and doing, then it makes useless the GSPs that are being granted to developing countries. And that ties also to the issue of export diversification. Problems with export diversification all connects to the fact that the environment is not just friendly for investors to bring in their money, because they are not sure that if we bring the money down to Africa, the political system will be stable, or there won't be any form of insecurity that would affect the ability to trade. So from after the lockdown since last year, we see that there are instances where timelines that the regulatory agencies are supposed to grant approvals or permits is just, we can't determine those timelines anymore, just because they are unable to cope with the fact that COVID requires that work. So these are just issues that are really connected with developing countries not being able to take advantage of GSPs and the difficulty in enabling export diversification. Then turning on to the question of, I think I've answered the question on can GSPs enable diversification. I think yes, they can. If attention is paid to particular industries where developing countries have some form of comparative advantage. For example, I know that most countries in West Africa have comparative advantage in production of cocoa. So if cocoa is one of products that granted more market access in the United States or in Europe as part of GSPs, I think it's able to, it's going to enable export diversification from petroleum to that agricultural product and some other agricultural products as well that countries in Africa have comparative advantage. Sparsha, I'm not sure if I got your question correctly. That again, so that I know that I'm answering you correctly.
No, I was just wondering if putting more conditions on these developed countries in the GSP programs would be counterintuitive in getting the benefits in the first place.
I do not think so, because they have the discretion. GSPs are so like is an exception from, well, not trying to answer the question you raised earlier whether SDGs are exceptions or part of the rule, but I see it as granting exceptions to developing countries from complying with the principle of most favored nation. So I do not think that developed countries would feel like they are being stopped from exercising their discretion. They will always be able to exercise discretion, because SDGs generally is from like an exercise of discretion by developed countries. So whether we put more conditions on them or not, which one they want to do, which one they do not want to do.
And you know, I actually think, Sparsha, in this conversation is very similar to a question that's been asked in the public chat by Varen Thorn, who says the non-economic conditions imposed on developing countries that require compliance with labor standards and environmental standards, or the need to liberalize their markets, can be abused by developed countries. And this is something Sparsha is hinting at with this notion of discretion, right? They've been used as an excuse to take away GSP as a form of retaliation if developing countries wish to protect some of their own industries. Such conditions may be used for developed countries' self-interest rather than as an incentive for developing countries. Is more regulation really what's needed to prevent this? So this is an age-old question, and it exposes some of the tensions we've seen across trade and development. Josephine, you want to give it a shot?
This my research, or my broader research, is informed, or this informed my broader research of how then do we ensure that it's not a form of push agenda of a developed country onto a developing country. And so I thought perhaps if we are able to define within the WTO what stands as development, financial, and trade need, we'll be able to curtail such acts of developed countries extending or pushing any agenda forward within the World Trade System. But then I'm not sure more regulation is what is required, but perhaps more concrete interpretation of existing rules on the use of GSPs and PTAs generally.
Thanks, Josephine. And as you all have noticed, there's one question I've been kind of urging the authors to consider, which is how to make whatever standard they're advocating as concrete as possible, with an eye towards this very issue, right? The more ambiguous, the more vague, and the more open-ended a legal standard is, the more discretion governments have on imposing them in whichever manners they want. But the more concrete we have, the less discretion, then the more controlled our trade system really is, which is, I think, kind of at the heart of all of this. Now, we may all disagree on what those objectives of trade should be. I think that that's an ideological approach, but I think that we can probably all coalesce around an agreement that discretion is not what's being asked here. Rather, what's asked is predictability, concrete standard, and fair and even treatment. Now, Rizwan, I robbed you of the opportunity to ask Sparsha your burning question. So we have about 5-7 minutes. I'd like to turn things back now to Sparsha and Rizwan's discussion. And again, audience members, please ask questions as you wish. Xinyan, we also have a question in the audience for you, but Rizwan's been waiting very patiently. So Rizwan, your questions.
Thank you, Desirée. Now, Sparsha, I think let me just go one step further. So you have very meticulously focused on the customary practice of the GATT and the WTO, or whether or not the practice of self-declaring is really customary. But if I may just take one step further and put to you that even, let us assume for the sake of argument, that this practice of self-declaring was not sort of customary practice of the GATT or WTO, because there was some sort of scope for challenging them. Now, if we take that position, which in a way is a bit unfair to ask you, because that was not really the focus of your paper, but if we take that step, what do you think, whether you find any merit in the US's so-called objective criteria, the 4 criteria that the US proposal includes, or the public position that European Union has taken? And secondly, both in the literature and also I think in the European proposal, there is some sort of indication that they would like to see a sector-by-sector approach. So my concern with that sectoral approach is, for many countries, particularly the LDCs and smaller developing countries, they may be specializing in one product like cotton, or for my country, it would be garment products. So in one particular product, they may be very efficient. They may have a significant market share in the world. But in terms of their overall trade performance, they may still be a very, very small player. So should you like to share your thoughts on that? That if there is any sectoral approach, what challenges could you face? So thank you. Although I know these are not squarely related to your paper, so maybe slightly unfair to ask you on this.
Sparsha, do you want to try to answer this in about 2 minutes, or should you punt, given that it's not the direct focus of your paper?
Briefly, maybe give my thoughts in less than 2 minutes. That's okay. So yeah, thank you for your questions, Rizwanul. So assuming self-declaration in itself is a customary practice, what that would mean, or the consequence of that, is the United States proposal can perhaps be legally challenged as not being within the WTO structure or the framework that we currently have. So having said that, what the United States has proposed, in my opinion, on that, well, I don't think that the criteria that they have proposed is backed by any kind of an economic or reasoned approach as to how they have categorized it. I think more than 30 countries would fall within one of the 4 categories they have put forth. So perhaps more discussion on how or why they have come up with these criteria would help countries understand it better and take the discussions forward. With respect to the EU approach and the agreement by agreement or sector by sector approach, I think that's an interesting approach, and we will probably see some element of it in the fisheries negotiations that will hopefully conclude soon, with China being the major subsidizer and countries pushing back on the SDG provisions within that. So if that does come through, and keeping in mind we already have kind of TFA giving countries the freedom to take in the obligations that they can, maybe that will actually change the practice of members towards the direction of a sector-by-sector approach that will be accepted by all in the longer run. Thanks.
Sparsha, you have diplomacy in your future. So Xinyan, let's try to get this a nice question really quickly. He asks, how, quote, pragmatic do you find it for the WTO to add and pursue what might in effect turn out to be a 9-year objective? Can you answer that in 1 minute?
Yes, I think firstly, we ensure an objective assessment standard of review in order to solve the problem of the WTO itself, and then we try to help the United Nations to strengthen the implementation of the SDG. Yes, we still have nine years until the deadline of the SDGs, but the story of pursuing sustainable development will not be ended in 2013, I'm sure, because we have already 2 initiatives from the United Nations for sustainable development. So future, we will have something to do. So right now, the WTO need to prepare for the future, I think.
Wonderful. So without any further questions from the audience that I see, our time is closing. So I'd just like to thank our audience members for taking the time to join with us in this conversation, looking at how the objectives of trade governance and development may be at odds? Are they irreconcilable? I think that our authors establish or demonstrate strongly that the answer is no. Maybe they are reconcilable. We all have different approaches, we all have different views, but some commonality across those views seems to suggest that with more concrete rules and standards and less state government discretion, we might eventually find a way of ensuring a fair and decent development that doesn't allow governments to retaliate and protect against trade, but rather one that opens up, facilitates a fair type of trade that shows that we're adhering to a common set of rules and principles and not of unilateral trade action. So thank you all for coming. I'm going to watch this space closely to see your final papers because they are interesting, and I encourage our audience to do the same. Have a wonderful evening, afternoon, or morning for you all. Bye-bye.